Welcome everyone to the Iowa Law Review Symposium on the Future of Law and Transportation. My name is Gregory Schill, and I am a law professor at the University of Iowa. At this time, I'd like to turn it over to Kevin Washburn, Dean of Iowa Law School, to welcome us all formally.
Good morning and welcome virtually to Iowa City, Iowa, America, and the University of Iowa College of Law. I'm pleased to see so many people logging in this morning to this important event. Our lives are governed by federal transportation policy more than you know, and how that policy is translated locally. Federal laws literally map out our lives, and the implications of these policies are recognized by some, but rarely break into mainstream consciousness for most of the rest of the world. In Washington, D.C., these bills that do this go by odd acronyms like ICE-T and T21 and Safety-Loo, and more recently, MAP-21, and most recently, the FAST Act. Significant spending through these massive transportation bills and other legislation changes how we live and work. And as a sometimes federal official myself, I have happily spent hundreds of millions of these dollars. And I know I've got a sense of how important all of this is. Today is an important time in our country, and it is looking like we may be at an important pivot point around a lot of issues related to climate, energy, and yes, transportation and the way we live. In fact, we may indeed find out more about that later today. I think a lot of people are hoping for some finality here. Let me say I am proud of our own Professor Greg Schill's important work in bringing new attention to a new audience of the impact of national transportation policy. And I want to thank all of you for being here today to join. While it would be good to have all of you here in the Boyd Law Building in Iowa City, the truth is I think we can reach a lot more people through Zoom. And so thank you for convening through Zoom for this important event. As today's first speaker, I need to thank some people, and I want to start by thanking our students and faculty who had the vision for this important event and who worked nonstop to make today happen. So first, of course, Professor Greg Schill. He's the visionary here, the leading scholar on our faculty in transportation law and host of today's event. Professor Jason Rantanen also deserves thanks. He runs our Innovation Business and Law Center, and it drives a lot of our innovative thinking around the College of Law. Staff member Sara Clark, she provided significant support to help coordinate and convene this event. Instructional technologist Corey Haight, our video specialist at the College of Law, who's been one of the hardest working people in the law school since about March of this year. Dana Waterman, our wonderful editor-in-chief of the Iowa Law Review, which is the 11th most influential law journal in the United States based on scholarly impact. And finally, Haley Sherman, our Symposium articles editor, who has worked hard to get us to this day, and I fear that her editorial work is just beginning. I'm also pleased to welcome all of our distinguished panelists today. We have two great, outstanding keynote speakers later, former Congressman and U.S. Secretary of Transportation, Ray LaHood, and Beth Osborne, of the Director of Transportation for America. And we've got a wonderful panel coming up right away. So I wish we could give applause to all of these great people for being here and all the great work that's gone into this, but I hope you will find ways to extend your support and your gratitude virtually over the course of the day. We are so glad that you are spending time at the University of Iowa with us today. Let me now turn the virtual podium to Professor Jason Rantanen, the Ferguson Carlson Fellow in Law and Director of the Innovation Business and Law Center here at Iowa Law. Jason?
Well, thank you, Kevin. So on behalf of the Iowa Innovation Business and Law Center, I'm delighted to welcome everyone to this virtual symposium on the future of law and transportation. The Innovation Business and Law Center was created to bring together scholars, lawyers, and policymakers to discuss cutting-edge legal issues. Transportation has long been a major area of innovation, from Roman roads to steamboats and rail systems to personalized transit devices like bicycles, automobiles, and scooters. Decisions about transportation have also affected much of human society, from where people live to the flow of wealth to access to basic resources like food and healthcare. Having lived in many different places, from a small, bikeable town in my childhood to a college at the top of a hill, to a small northeast city, to the south side of Chicago, to Washington, D.C. and San Francisco, and now in a very walkable college town that is separated by a river. I've seen how decisions about and access to innovations in transportation have shaped everyday life. We at the IBL Center are delighted that we can support today's symposium with its phenomenal slate of speakers and commentators. They explore how laws relating to transportation shape virtually every aspect of human existence, and how those laws in turn have been influenced by a variety of social forces. Many of the speakers today also tie in especially well with our Fall 2020 IBL speaker series on race, business, and the law, and I'm proud of the many viewpoints that are present today. Greg Schill, Dana Waterman, and Haley Sherman have done a fantastic job putting together the program today, supported by Sara Clark, our terrific IBL administrator, as well as Jill DeYoung and Laura Kivligan in communications, and Corey Haight in IT. And I'm looking forward to watching today's symposium, learning about things that I didn't know, and thinking about the new ideas that our wonderful speakers are going to bring to the table today. So with that, I'm going to turn it over to the Iowa Law Review, Dana Waterman and Haley Sherman, for a few additional words of welcome.
Good morning, everyone. I'm Dana Waterman. I'm the editor-in-chief of the Iowa Law Review.
And my name is Haley Sherman, and I am the Symposium Articles Editor for the Iowa Law Review.
We are so pleased to finally welcome you to our 2020 Symposium on the Future of Law and Transportation. I wish we could see you all here in Iowa City, but we are excited that we can make this event accessible to even more people in a virtual setting.
Today, we are going to hear from a variety of speakers, both from the legal and non-legal realms, on the topics surrounding the law, policy, and potential of transportation. This is the first time an event like this has ever happened. Knowing the wide impact that transportation law and policy has on areas like the environment and public health, we are honored to present today's event, and we are excited to publish the presenters' complimentary written pieces in the Iowa Law Review's 5th issue of Volume 106, published in July of 2021.
We would like to thank everyone from the University of Iowa College of Law who's made this event possible, including Dean Washburn, and I'll echo a few of his and Professor Rantannen's thank yous. I'd like to thank Professor Greg Schill for putting this together, Professor Jason Rantanen and the Iowa Innovation Business and Law Center, Jill DeYoung, Sara Clark, Pam Funk, Diana DeWall, Laura Kaviglian, Renee Schilling-Arps, and Corey Haight. We would like to thank all of our speakers today, and we would like to thank in advance the rest of the Iowa Law Review staff for their work on publication of the symposium articles.
We just want to mention, if you would like to engage in conversation on social media, we would encourage you to use the hashtag #TransportationLaw2020.
Thank you all for attending. We hope you enjoy today's event, and we're going to turn it over to Professor Greg Schill.
Well, thanks everybody. I'm so glad to be opening this event today, and I'm so delighted that we've currently been joined by over 100 people, and we're expecting a good turnout today. We're very excited to have all of you here to hear from our panelists and keynotes. And so, as faculty organizer and host, it's my great pleasure to welcome you to the symposium on the future of law and transportation. A lot of thanks have already been extended, but I want to extend those. So I want to thank Dean Washburn once again for his steadfast and continuing support. I want to thank Jason Rantanen as head of the IBL Center for his absolutely critical support. The students of the Iowa Law Review, Haley, who was the symposium editor, and Dana Waterman, who was the editor-in-chief, as well as their staff, who will be working on the articles that come out of the symposium for the months to come. Sara Clark, Diane DeWall, Corey Haight, Laura Kivligan, and Jill DeYoung, many others in the Iowa College of Law building have been working tirelessly on this for several months, including making the transition from an in-person event, and we had all sorts of plans for that, to the transition and to what will hopefully be, as the dean alluded to, an event that reaches more people because of its Zoom format. I also want to add thanks to Chad Crow, who is the person behind the art that was commissioned for the program. You've probably seen it on the website and on the program, but there's a little image of it. I also want to thank Robin Hepker, who made the symposium graphics, such as the Zoom background behind Jason right now, that you'll be seeing periodically today. It's often said that the modern civil rights movement began 65 years ago next month on a city bus in Montgomery, Alabama, when Rosa Parks refused an order from a bus driver to give up her seat for a white man. The Montgomery bus boycott that followed helped power a historic, successful movement for civil rights and social change, a movement that continues to this day. But in the past 65 years, there's been a major change in how people get around. 60% of transit riders today are people of color. Not coincidentally, outside of a handful of cities in the United States, public transit has become a bare bones safety net service rather than a system like roads and highways that are taken seriously and receive extensive funding and bipartisan support that it needs to function as an effective network. Treatment of sidewalks and other active transportation infrastructure is even worse. As Dean Washburn mentioned, many of these decisions are made at the federal level. Others are made at the state and local level, but infused through all of them is law. This is the first scholarly conference that we're aware of, and we looked, that focuses on law and transportation as a subject of general public concern. By that, I mean today's speakers will be talking about hard social questions that relate to law and transportation. I'm not saying you won't hear some of the shiny new technology that has come across your social media come up at all today, but it's not going to be the focus. I think you'll find these hard social questions to be the focus today, and ways to think about addressing them that hopefully starts a conversation that continues long past this conference. In addition to hopefully being a path-breaking conference in itself, the other thing we wanted to do today is jumpstart a dialogue. Legal scholars comment on everything. You throw a dart at a newspaper, and you will find a law professor offering an interpretation or an opinion on a major topic of public concern. By the way, whether they're an expert on it or not. Really, topics ranging from the internet to policing to taxes, interest rates, foreign policy, housing, racial equity, gender equity, healthcare, and of course, anything having to do with constitutional law or litigation. One really glaring exception is transportation. And I find that a little puzzling for a number of reasons. Transportation is very prominent in society and public policy, as well as everyday life. Transportation is the connection between so many of the questions of our time. And scholars in other disciplines, and to be clear, some scholars in legal academia, including many of those present today, but overall, we have been outstripped by our peers in other disciplines, where they've really been doing incredible work on the connection between transportation and climate change, with transportation now contributing the biggest share of US greenhouse gases, the connection between transportation and structural racism, between transportation and economic growth, public health, and of course, urban planning, and really disciplines across the board from engineering to political science, economics, geography, sociology, even anthropology and urban and transportation planning have been laser focused on this for decades. We have fallen behind as a community of legal scholars, even as lawyers themselves remain integral to the planning, implementation, and politics of transportation. So we're excited today to be convening this event. But I think we will only succeed if we turn it into a bridge that helps bring legal scholarship towards the hard work that folks in other fields have done. And also hopefully there'll be some benefits for folks in other fields to see how legal scholars approach these questions. As I mentioned, next year, the Iowa Law Review will be publishing a special issue based on the articles presented today. So please do follow along, of course, here Please engage with Q&A on using the tool at the bottom of Zoom. That's how you can pose questions to our panelists. The panelists will have about 12 minutes to talk and then take about 8 minutes of questions. Now, mostly the questions will be from other panelists, but we do want to take some public audience questions when we have time. You can also use the Transportation 2020 hashtag on Twitter, and you can find the full program and information on the web. I could give you the address, but it's just easier to Google Iowa Law Transportation Symposium. Okay, with that, we will now shift to our first panel. Okay, this panel is on transportation planning and land use. It's our first of 2 such panels. We have Jonathan Levine, who is a professor of urban and regional planning at the University of Michigan Taubman College of Architecture and Urban Planning. He is followed by Audrey McFarlane, Associate Dean of Faculty Research and Development, and Dean Julius Isaacson, Professor of Law at the University of Baltimore School of Law, and Sara Bronin, who is the Thomas F. Gallivan Chair in Real Property Law and Faculty Director of the Center for Energy and Environmental Law at the University of Connecticut School of Law. And she's also been very closely involved in land reform efforts in Connecticut and New Haven. So without further ado, Jonathan Levine.
Great, thank you very much, Greg, and thanks for organizing the conference. Especially thanks for conceiving of this idea that brings us non-lawyers into interaction with you lawyers, and I hope for a great and productive exchange. I'd like to, is everybody seeing my PowerPoint? Yes, good. I'd like to take you forward to an ordinary day in the post-pandemic era. An ordinary day in the post-pandemic era, you've got tasks you got to do today. You have to get to work and back, maybe to school, maybe drop off kids, maybe you want to go to a restaurant. So you have a list of things you're hoping to do today. The only thing that's not ordinary about this day is you've got 2 different cities in which you can choose to fill your task list. City number 1 on our left-hand side has destinations that are close to their origins and destinations close together, but it has slow traffic. City number 2 has origins and destinations that are spread farther apart, but the traffic is fast. And I'll add one more assumption. In city number 1, because of the closeness of the origins, the destinations, you can fill your task list with a smaller investment of time and money than in destination number 2. So now the philosophical question is, which city has the better transportation system? And most of you, I'm not going to conduct a poll here, but I suspect most of you would say, well, I'd rather spend less time and money in transportation if I can reach the same number of destinations. Therefore, close destinations with slow traffic is a better transportation system, even because I can end up filling my list with less investment of time and money. If you think that, you're thinking in accessibility terms about transportation as opposed to mobility terms about transportation. And I'm going to argue that embedded in our institutions and embedded in all of our ideas about institutional reforms are implicit problem definitions regarding transportation. Historically, our problem definitions have been mobility-based, but the mobility-based problem definitions are inconsistent with the very purpose of transportation, which is to reach destinations, not to move per se. A quick definition, the distinction between mobility and accessibility. I like to talk about them in terms of what would constitute an improvement in each. So an improvement in mobility is an increase in the territory that one can reach for a given investment of time and money, whereas an increase in accessibility is an increase in the value of the destinations that one can reach for a given investment of time and money. if we start from the first fundamental purposes, the purpose of transportation in almost all cases is reaching destinations, then we would have to conclude that accessibility is the problem definition that's consistent with human behavior and human motivations. Problem definitions are carried in people's hearts and minds, and they're also carried in our legal institutions. So this talk argues for what I'm going to call the accessibility shift, which is a shift in the methods and modes of transportation planning from a mobility basis to an accessibility basis. Now, often accessibility is equated with walking, cycling, transit, basically the alternatives to the automobile, and mobility is associated with the automobile. That is not the definition that I'm working from. I would argue that there is a mobility and an accessibility approach to planning for any transportation mode. For example, embodied in the standard engineering manuals is a mobility approach to planning for pedestrianism. The quality of pedestrianism is garnered by the ability of the pedestrian to move, rather than the ability of the pedestrian to walk to any destination they might want to walk to. So let's not a priori decide that accessibility is associated with any particular mode. In addition to being embodied in the hearts and minds of citizens, of professionals, of decision makers, mobility problem definitions are embodied in methods and metrics in transportation planning, transportation engineering. These methods and metrics are used to guide decision making, such that it's not enough to change hearts and minds, because the individual planner or the individual policymaker or the individual decision maker would be very hard pressed to alter their practices when institutions require them to act in a mobility-centric fashion. Premier tool in mobility-based planning is level of service, which is roughly the degree of freedom of movement of any particular mode, but level of service historically has tended to emphasize the movement of cars, auto mobility. And this idea of level of service comes up in a number of different ways in our institutions. For example, we have municipal level of service standards in our planning documents and municipal ordinances. I'll give you a little quote from my various institutions here. Under no circumstances shall the development cause a drop below level of service E, XC, volume to capacity ratio of greater than 1.0 at any signalized intersections for any analysis scenario of the city of Lakewood. Okay, so here is a rigidly defined mobility-based problem definition that any individual planner, any individual engineer would be hard-pressed to change autonomously. The change would, of course, would require legislative change in this case. It's not just at the municipal level, it's also at the state level. Here's an example of the state of Oregon, actually one of our more progressive states when it comes to transportation. I'll read the quote and then I'll give you the context. The following volume to capacity ratio based methodology is recommended as a first option when developing alternative mobility targets for state highways. So here's the state of Oregon telling municipal entities in the state of Oregon, listen, you have to adhere to our mobility targets. If you can't adhere to our mobility targets, we're going to give you a methodology that's going to allow you to generate new mobility targets. But the thinking remains stuck in mobility. So basically, the state of Oregon is saying to municipal and county governments, okay, we understand you can't all have free-flowing traffic, so you might need to drop your mobility standards. But in fact, the urban areas, which are the ones that have the quote-unquote mobility problems, are the highest accessibility areas in the state. So instead of merely dropping your mobility standards, the thinking could change to developing accessibility-based standards, in which case you're not merely lowering your standards, but actually increasing people's opportunities to reach destinations. Third example comes in the form of concurrency, which is often a state-level institution, or adequate public facilities ordinances, which is often a local municipal institution. I'll read you an example from Charles County, Maryland. No preliminary plan for a subdivision or a major site plan required for a zoning permit shall be approved unless the Planning Commission first determines that the proposed subdivision or development will not adversely affect the adequacy of public facilities serving the area, project, or development. So far, so good, because, by the way, this applies not just to transportation, but to things like sewage. You can't build a development if it's going to flood the area. Who's going to object to that? Nobody's pro-flooding. But when it comes to transportation, let's see what it means. Service levels shall at all intersections in the immediate vicinity of the project as designated by the zoning officer be defined by the current edition of the Highway Capacity Manual published by the Transportation Research Board. In other words, define your mobility standard and don't develop unless you can maintain that mobility standard. That ultimately becomes a binding constraint on development, which forces development into a more remote, more low density, more auto-oriented areas. In other words, it becomes a constraint for allowing more people to live, work, and play in high accessibility areas, which is exactly the opposite of what one would do if one were pursuing an accessibility-based problem definition and planning. A notable effort to reform has been evident in the state of California in the last few years. This is in the reform of the California Environmental Quality Act, which previously defined congestion as an environmental impact per se. That had a number of very negative consequences. A lot of very pro-environmental transportation reforms were attacked under the CEQA, California Environmental Quality Act formula, because they threatened to create automotive congestion. This reform says, actually, no, we're not going to treat congestion as an environmental problem per se. It's vehicle miles traveled that's going to be our metric of environmental harm. So I'll read the language. In developing criteria, the office shall recommend potential metrics to measure transportation impacts that may include but are not limited to vehicle miles traveled per capita, etc. I would call this a step forward, and it's a necessary element in transportation policy reform. But I want to emphasize that the purpose of transportation planning is not mobility, but it's also not reducing vehicle miles traveled. Just to give you one way of thinking about this, I want you to imagine a planner choosing two different alignments for a transit investment. One goes through a rich area, one goes through a poor area. If that planner's criteria is reducing vehicle miles traveled, the answer is clear. Put your transit investment through the rich area. They're the ones who have a lot of cars. They're the ones who drive a lot. In other words, a problem definition that's exclusively around vehicle miles traveled tends to privilege travel that's high vehicle miles traveled to begin with, and assumes that if you're not driving a lot, which poor people don't because they can't afford to, there's no transportation problem. So a vehicle miles traveled definition is a step forward from a mobility definition, but it can never be adequate as a definition of the transportation problem. Finally, just to wrap up, I like to talk about three roots of reform: the bottom up, the top down, and the outside in. The bottom up is that individual planner or decision maker taking decisions to work in an accessibility-based fashion. But as we've seen, that person is going to be very, very limited because the institutions demand of him or her mobility-based analyses. So for that reason, reform of institutions, reform of funding practices is necessary. The outside-in route of reform is when we look at other fields such as real estate or other fields such as public health. These are fields that are very, very interested in the capacity of people to reach their destinations. In other words, these are fields that are already accessibility based. We can learn from the outside and reform practices in that way. So ultimately, I'm saying that the institutional reform for accessibility is a necessary, surely not a sufficient condition, but there's an interaction between the problem definitions that people hold in their hearts and minds and the institutions that embody those problem definitions. Thanks.
Okay, thanks. Reminder to my fellow speakers, if you have questions, please use the raise hand tool. But I think we'll start with a question from the audience. Why not use person miles traveled (PMT) as an alternative to VMT? Or maybe, would that address the kind of latent? I guess there's a few issues there, right? So one is vehicle miles as opposed to other types of miles, and that's what that question addresses. There's also pregnant in your in your comments the notion of latent demand, and I wonder if this would capture that, or you need another third tool.
Observed travel behavior, whether vehicle miles traveled or person miles traveled, cannot be an indicator of the benefits that people receive from the built environment. Just to give you an example, I cite in my recent book the average vehicle, and let's see, average time to work in downtown Washington versus average time to work in rural Kansas. And it's identical. I give two examples where there's two identical average times to work. But the point is that in downtown Washington, D.C., one can reach so many more destinations for that investment of travel time. So the problem is there's an illusion that that travel behavior indicates the value that we receive from our destinations, but it is in fact a function of our ability to reach destinations. If I can only reach one job, I'm far worse off than if I can reach 100,000 jobs. I've probably got a better choice of job. I've probably got a better job. I've probably got better working conditions. I have more flexibility. There's all sorts of reasons why the potential interaction with our environment is the reliable indicator of the benefits we receive from a transportation system.
Okay, great. We've got a question from a panelist here, from Professor Clayton Nall. How much do you see the goal of VMT reduction conflicting with social justice / equity goals, particularly with respect to climate? And it's a big topic. We have just 2 minutes left on this right now. So yes. With that,
let's see. I'll start with the optimistic side. I for the most part, I see consistency between social equity goals and VMT reduction goals. When we reduce exclusionary zoning, we're giving lower income populations the possibility of living in high accessibility areas where they don't need to drive so much, as an example. There are going to be other examples where, for example, policies to there have been policies to try and put cars in the hands of carless households, which is a very, very important policy that works for many households, doesn't work for other households. That would be an example of conflict. So there's no automatic resolution of the two. The argument that I would offer is that we need separate indicators of our accessibility goals and of our environmental goals, and not conflate the two. For example, by treating vehicle miles traveled as the purpose of transportation planning.
Okay. There's some great questions, but we are coming towards the end of our time, unfortunately. So
thank you.
Thank you very much for your remarks. Next up is Deborah Archer. Oh no, I'm sorry, I'm on the wrong list here. Audrey McFarlane.
Thank you, Greg. share my PowerPoint. Good morning, everyone. I'm really delighted to be with you. I am a land use person who is venturing into the transportation waters. And in part, it's based on my upbringing in New York City and being a big public transportation user. But my interest is also influenced by an experience that I had in Baltimore City with respect to an effort to bring public transportation to a jurisdiction that sorely needed it. And we saw that the program or plans were summarily terminated. So there was a project for Baltimore called the Red Line, which was intended to be, as you could see it here on my slide, you could see it, I guess, blurrily in the background, that was supposed to extend from the west side of Baltimore to the east side of Baltimore. Baltimore City is a very urbanized place, but it actually has relatively poor public transportation. There's one train line off to the left, off to the west, and another one that runs north-south to the suburbs. And so the goal was to improve the transportation from east to west across the city. And in particular, to get from West Baltimore, which was a primarily Black area, over to the east side, which is gentrifying, but also was on the way to Amazon warehouse. And so 2 months after the Freddie Gray uprisings, the planning process for the Red Line had been in place for roughly 13 years and involved lots of public participation. The newly elected governor of Maryland terminated this planned Red Line light rail train project. And the reasoning was that it was a wasteful boondoggle. And later, the governor expressed that they had spent $14 million extra because of the Freddie Gray uprising. And so that therefore Baltimore had essentially gotten its share. So the cancellation was abrupt and it was shocking. And it reflected lots of politics, but also it reflected something going on in a state that has had a long fraught history with its Black population and in this context, Black mobility. And there's been a long sense that part of the underinvestment in transportation in Baltimore was indeed a reflection of that population. So having had this process go on for as long as it had with as much investment as had taken place, they had expended about $288 million in planning and preparation for this program. And in view of the amount of commitment that had been made to trying to get this project done, the question became, what could be done to avoid this in the future? Just a few words about the need that we're talking about. A television reporter did a test run. Let's see what a commute is like. And they tried to get from the west side of Baltimore to the Amazon warehouse, which was a journey of 7 miles. And it took 95 minutes on 3 buses, and they were unable to make it starting at 5:30 in the morning to get a worker there for the 7 a.m. shift. So the need was high. The investment locally was high as well in terms of there was a very involved public participation process. I attended a public meeting where one of the attendees, after the cancellation, one of the attendees said, but you know, we worked on this for 10 years. She said, I lost friends over this. I've lobbied people. We've really worked to try and make this come about. And now it has been summarily terminated. So the other dimension of this was that when the program was terminated, the federal funds were refused and the state matching funds were reallocated from the Red Line project to highway projects around the states. And the NAACP brought a Title VI administrative complaint to argue that that reallocation of resources from the primarily Black Baltimore City to the primarily white areas was a violation of Title VI. One of the difficulties, however, is that in a way, Title VI comes about too late to try and put the pieces back together again of what was broken. And so what I've been thinking about is there a way that we can consider all of these factors, consider how structural racism plays into shaping the lack of the quality transportation that meets people's needs, the influence of race in creating disinvested communities, the traditional opposition to public transit projects. And you have examples all over the country, as I'm sure this esteemed panel is aware of announce a public transit project, and there's opposition, Houston, Atlanta, Los Angeles, you know, all over. And so it seems to me that public transit is certainly stigmatized for a variety of reasons, but to the extent that class and race play a significant role in the, I guess, the kind of visioning about what it means or what it portends. So for example, we have an existing light rail line that goes from Baltimore down to the airport and passes through a suburban county, mostly white. And they had started to petition to close stops on the light rail line because of their perception that it was bringing crime to their areas. So there were angry petitioning that they felt entitled that they had the right to close off these transportation stops. So to the extent that mass transit, I would say, is racialized and stigmatized, I would almost call it Black transit, depending on the particular areas. Is there a way that the process can be structured to address this inclination to basically torpedo mass transit projects? I'm also inspired to, I guess, make this inquiry because this was not the only refusal of funds for mass transit projects. Around the same time, 4 other states, New Jersey, Florida, I have it in my notes, but there are a few other states that refused funds at the same time. So in the way that we've set up transportation funding, it's certainly under the auspices of the spending clause, where money is made available for projects, and there are certain conditions attached, usually for how the funds are used, how the project is carried out. But I don't believe that there's any control or any perceived ability to control the decision to refuse funds, because usually it's unusual for a project to, I guess, be stopped in the middle of the process the way that it was here. So there seems to be a new trend or possibility that these funds or these projects will be terminated or money that you were eligible for and had won, depending on a change in administration, there's a political ideology that says that those funds are going to be used for something wasteful and we're going to turn them down. So is there a way to control or limit the turning down of these funds? And it seems to me that in the case here where we had, so on the one hand, we have federalism concerns. One argument might be that the governor is free to decide what makes sense politically within their jurisdiction or economically or is beneficial, and that they have the autonomy under 10th Amendment principles to make those decisions for their jurisdictions. But I would argue that when it comes to mass transit in particular, or public transportation in particular, that with that type of transportation being racialized, that there should be something approaching a presumption of disparate impact or a presumption of discrimination that's involved. And that having accepted the funds, that certain either contractual or equitable principles should be applied. So if we apply, let's say, the contractual equitable principle of the covenant of good faith and fair dealing, if we apply a land use principle of vested rights, or if we apply a land use approach that there are certain decisions that we will not defer to, but we will actually require you to produce evidence. So what I have in mind is that we would just make the simple fix in terms of making these funds available, that one of the conditions of receiving the funds is that if you were ever going to turn them down, just tell us why, or lay out your reasons. Now, it might sound like that's minimal, but very often when you have to spell it out, you would offer your reasons, but certainly we would want to see substantial evidence in support of those reasons. Another approach could be that if there are elaborate public planning requirements to receive the funds, perhaps there should be public planning or hearing requirements to back out of the receipt of the funds. So there are many ways to structure it, but I do think that there's a new phenomenon that we are not really focused on, which is that it is politically perceived to be politically beneficial to defund these types of projects. And if it is politically beneficial and it is going to have a racially disparate impact, and we can anticipate that in advance, we should consider putting these kinds of conditions on the receipt of funds, that if you want to refuse it, then offer some kind of justification to support that refusal. And I will end there.
Thanks. Terrific. David Prithurch.
So thank you for the really interesting talk. I'm just wondering, can the NEPA process help at all? I'm wondering in terms of the environmental justice provisions of NEPA, which are kind of about avoiding harm, but what were, if you had a whole definition of promoting environmental justice, would it be harder to turn down these projects or at least fund things that were not like highways? So thanks again.
Thanks, David. So is your thinking that if there were some kind of racial impact statement involved in the planning to get in, that would certainly, I would say, be quite beneficial, but it would need to also be tied to the backing out.
Okay, thanks. Noah Kazis.
Thanks. I really love the paper. I was wondering how you see sort of the cancellation of rail projects early in the Obama administration fitting into this scheme. You know, there's sort of somewhere between highways and transit, I think less racialized than the transit projects you're talking about, and whether looking at those as sort of an intermediate category would be helpful in terms of drawing the lines for where we'd add the scrutiny, where we wouldn't, what tools would work. Thanks.
So those were the projects that I had in mind, that there was a cancellation. There was also the cancellation. I recall Chris Christie canceled the money for the Amtrak tunnel. And so when you say intermediate example, do you think that those would not meet the racially disparate impact standard, or could you?
Yeah, I just mean they seem less clear in that respect than, say, the Baltimore, light rail, but maybe have some features of it in some places, not in others, depending on where, it just seems less racially disparate, but not, right? It shares some features of the light rail as like the archetypal case, but not others.
I would make it a presumption of disparate impact, and it's up to you to rebut it. So even in the intermediate cases, I would say that there's been such a consistent pattern. It almost begs the question of, as lawyers, we may all gasp at this, but I think I'm just fed up. Like, why do you have to keep proving it? It's obvious.
That's really helpful, thanks.
There's a question about how COVID fits into this. Of course, people are taking transit less. A lot of transit agencies are retrenching right now, fighting for their lives. How does that change the conversation around expansion in general? And how does it change it around new service that is equitable?
I just don't see, personal vehicles as being a substitute in some places for public transportation options. So I think we're going to find ways to travel together safer, but I don't see COVID as obviating the need for public transportation.
I agree completely, and hopefully won't be with us forever. So, and these capital projects take absolutely forever to unfold and have a lot of federal backing. So hopefully there's a way to do that. Dan Rodriguez has a question about the remedy in the event that a disparate impact claim succeeds. How does a court actually affect expenditures under their traditional powers? I might add to that, is there maybe a role for a positive right, like we have in some states, a positive right to education, where I'm not an education law expert, but it seems like there is a history anyway of courts ordering or managing expenditures a little more closely.
So the disparate impact in court, my argument is that that's almost too late. So the remedy is going to be some allocation of funds, and whether or not it would go for the same project or whether the project would be reinstated is one question. And I'm trying to say that same concern needs to be structured in legislatively at the beginning of the process, that ideally that we could avoid some of this by at least reducing some of the unfettered discretion to just terminate a project regardless of how far along it was. And in part, some of the justifications for me are that there's a localism involved in here, and a beneficial localism that took place, and that in recognizing that the feds are making money available, but that the way that it can be used is in a way that's kind of racially detrimental, that it would, in a way, try to elevate the localism aspect and ensure that those voices are not disregarded.
Terrific. Well, thanks so much, Professor McFarlane. We are going to move on now to Professor Sara Bronin.
Can you see me? I think maybe Professor McFarlane may need to stop screen sharing. Okay, great. So thank you, Greg, and thanks to everybody for being here. I am just getting my slides up here for myself. I'm not, or my notes up. I'm not going to use slides today. I have a very low-tech whiteboard. In part because, you know, I know you're going to see a lot of images today and a lot of really great PowerPoint presentations. So I just thought I'd maybe just talk directly over the few minutes that I have. So today we're probably all refreshing our Twitter feeds and looking at the election results as they come in. And I will just start by saying that this is very relevant to the topic that I'm talking about today, because what I'm talking about today is federalism. And the election right now is is federalism on a dramatic and very real scale right now, because what we have in that instance is a situation in which states have to carry out federal election mandate, but the way they do it is kind of up to them. And so that is federalist framework for election law. But today, instead of talking about elections, we're going to talk about transportation law. And I do see the federalism problem cropping up across many of the presentations you'll see today. Professor McFarlane mentioned it towards the end of her talk. And of course, it's central in determining in that case how funding decisions get made. Today, I'm mostly going to talk about design standards. And so I encourage you to continue the conversation on Twitter. You might not be able to, there's a little bit of a glare, but I'll try to tilt it so that you can see. Just stepping back, I was motivated to write a paper on this topic for lots of different reasons, but mostly because I keep knowing or being close to or, you know, 1 degree of separation away from people who have been killed as pedestrians on roads. And so the question for me is, what is law's role in that? You may have seen even last month, a Yale law student and a crossing guard were killed in the same week in New Haven. And, you know, just getting frustrated about the fact that we actually know how to prevent a lot of this and we're not doing it. So as an architect, I wanted to focus in today on design issues. So there's lots of different issues we can blame for the rising rates of pedestrian death. And I know Vanessa later is going to talk more specifically about pedestrianization and those issues. But what I'm going to focus on are street design standards and car design standards. So what I mean by street design, so street design really refers to exactly what it means, how a street is laid out, how many lanes there are, how wide the lanes are. Wider lanes lead to faster driving, whether there are sidewalks or parked cars or trees, all of which lead to slowing of vehicular traffic. And what I mean by car design standards is how we allow for cars to be built. So do we allow them to be do we allow them to be oversized? And we've all seen larger and larger cars, heavier cars, stiffer cars, cars that protect the occupants, and taller cars. Again, all of this protects the occupants of the cars, but the consequences, the externalities of that design are brought around on the rest of us. Other consequences other than direct potential danger of car design are also indirect effects, including greenhouse gas emissions. So the transportation sector, as you'll hear probably again and again today, is the largest emitter of greenhouse gases, according to the EPA. So the truth is that we know what the right standards are, both for vehicle design and for street design. And the problem is we're not using them. We know what protects human life. We know what contributes to climate change. And we just are not incorporating those standards into our laws. And so for me, the question as I was delving into this topic was why? And I think the why is really federalism. So we start with the Constitution, and Professor McFarlane mentioned part of this, but part of it is the 10th Amendment. So the Constitution, of course, reserves powers to Congress, and the 10th Amendment reserves certain powers to the state. Now that sounds very simple, but of course it's not. There's a lot of different ways to think about the relationship between federal, state, and local governments. And so we'll just, remind folks, federalism is about the relationship between federal, state, and local governments. And there are lots of different ways to think about this. So there are some scholars who think that we should have clear boundaries for state and local control, and that states' role in the federalist system is really to assert their autonomy. So I'm just going to throw up a few words while I'm talking. So autonomy, this is what you might consider the autonomy model of federalism. Then there are those who believe that state and federal governments should work together to achieve common goals. And we sort of call this the cooperative federalism or the cooperation model. I'll just throw that word up here too. And then finally, there are those who believe that states should use the powers that Congress granted them to tweak, dissent, or challenge federal law. And so we call this, maybe a strand of federalism that thinks about the states and local governments as in constant tension. But whatever the model, whether it's the autonomy model, the cooperation model, or the tension model, I guess you could call it, the thing that all scholars talk about as the primary goal of federalism is really the same, and that is balance. And so when you look at the question of balance, it's all about weighing different priorities and looking at how things kind of shake out over the course of time. But what you're really evaluating, and scholars have in some instances tried to evaluate federalist schemes against various values. And across those three values, I think they boil down really to three. And so the three values that I want to focus on today that I think are relevant across multiple models of thinking about federalism are representation. So the ability of people to be heard by their government. Then the next one I want to talk about is liberty, which is the ability of people to be protected, whether it's constitutional rights or natural rights, maybe even from government. And there's a strand of scholars that are focused on this question. And then, of course, practicalities of scale. It's a little bit of a longer one. All right, so practicalities of scale. And I'm looking at my board here, and I'm realizing that what you can see is backwards. Well, this is an exercise in mental gymnastics then. So enjoy that. And I had a chat queued up here. All right, so I'll have to learn how to write backwards next time. This is my first time experimenting with a whiteboard. All right, so looking at this, representation, liberty, practicalities of scale, we really want to apply this right now to election law, but we're going to apply this to transportation design standards. Oh, it is frontwards for you. All right, great. Excellent. Excellent. All right. Thank you for the comments in the chat. All right, so but first we have to know how these standards work. So let me just go through briefly and kind of talk about how each of these standards work, again, at a very broad scale, because we don't have a ton of time. There are 4 million roads, 4 million miles of roads in the United States. Street design standards depend on the type of road. So I leave out in the paper that I'm writing both interstate highways and unpaved rural roads, which unbelievably account for 31% of all roads in this country for obvious reasons. So there's no amount of design standards that can help improve outcomes on highways or unpaved rural roads. So it's really the rest of the roads in between, state roads, local roads, and federal roads that are not interstate highways that I'm thinking about. So if you look at the, I'll put a new SSR link in the chat in a second. Just saw that chat. All right, so if you look at I'll just put it here. There's a standard of for federal design, a national standard that has been established, and it's called AASHTO. It's called the Green Book, and it is essentially set out by a bunch of engineers that have taken it upon themselves. Originally a federal highway lobby, they've taken it upon themselves to design standards for all streets. It is very focused on the car and enabling fast movement of the car. So in addition to AASHTO, which is a national standard, there's emerging a trend to try to adopt at the local level another standard called the NACTO standard. We don't have a lot of time to get into that, but it's more of a standard that focuses on pedestrians and all users. But in general, the states and local governments adopt this national standard called AASHTO. We also have in vehicle standards, federal standardization, mostly in the production of vehicles, their design. However, we have seen states try to, and even local governments actually with Bloomberg and the Prius taxi attempt to try to regulate the kinds of taxis in New York City. We do see state and local governments trying to do more than the federal government has in terms of car design, particularly when it comes to emission standards. Recently, over the last few years, Bloomberg's attempt to get Prius taxis in New York City was shut down. California's emission waiver was just denied by the Trump administration. And so you see that even though state and local governments are trying to innovate through this federalist system, they keep getting batted down. Okay, so what does that mean for the topic of federalism that I wanted to talk about today? Let's go back to these three things: representation, liberty, and practicalities of scale. And the basic argument in my paper is that we're not well represented as individuals in the development of design standards. This AASHTO standard that I mentioned, I'm just going to put an X through it because it's a terrible set of standards. But the AASHTO standard is developed in secret. We can't even get copies of the standard without paying $1,400. There's actually a series of lawsuits against building codes, including a case on upcodes in the Southern District of New York, which also a privatized legal standard that people can't even see. And hoping that resolves in favor of the public interest in seeing building codes will also perhaps play into the public's interest in seeing design standards. So representation, and I know I just have a minute left, so I'm going to just go through these really quickly. In the area of liberty, so Akhil Amar is perhaps a leading scholar who talks about liberty as the primary goal of federalism. We haven't really talked about or developed legal theories that kind of relate to this idea that we have an individual right in being free from certain death on roads as pedestrians, that we have legal rights to be free of emissions, dangerous greenhouse gas emissions. And so we should try to develop theories in this area. If we want to fix something, we should try to develop theories in this area that relate to individual liberty and use those through the court system. And then finally, the practicalities of scale question. This might be the area where the vehicle and design standards are best suited or best served by the federalist system. But even here, we can see that there are impacts across local government jurisdictions, across state jurisdictions in the way that we design our roads in particular, and it's something to take a look at. So what is our solution? Greater transparency, rational decision-making, development of legal theories about individual rights, possibly also looking at government immunity and preemption analysis. So I'll just conclude by saying that there are lots of things that affect what I'm concerned about, what I see, and again, too many people dying on our roads, traffic laws, high speed limits, low gas prices, driver distraction. But these would not be as big of an issue as they are if people actually had safe roads to drive on and cars whose drivers actually internalize the externalities that they create. All right, so with that, I'd love to connect on Twitter, and I'm looking forward to hearing your questions.
Thanks so much, Sarah. We have a question from Beth Osborne.
Thank you so much for your presentation. I spend a lot of my time doing technical assistance with departments of transportation. These issues come up nonstop, and they're very hard to communicate to those that would like to see a change in the program, which is greatly frustrating. One of the things I wanted to ask you about is when I do technical assistance with departments of transportation, particularly at the state level, the engineers that would like to implement safer designs are often stymied by their own legal counsel, who say that they will get sued if they implement designs that kill fewer people. Their basic position is the AASHTO guide tells them they may not, in spite of the fact that the word shall appears nowhere in the AASHTO guide.
Absolutely.
So what is your experience there, and what do you suggest we do to overcome that?
Yeah, this is a great question. And I think that's the sort of teaser that I put in my very last comment about immunity. So you see that in general, the theory of the lawyers who are speaking is that if you use the AASHTO guide, you basically, because it's accepted as the industry standard, you have immunity from any bad consequences of your decisions. If you try to move to NACTO, if you try to experiment with different design configurations, you might open up the municipality or the state or the federal government to some kind of liability because you're going out of the norm. And I think what's needed here is really a close look at what immunity means. We've already seen a case in New York City where a child was killed in Brooklyn, and New York City was found liable for not having design standards that make their roads safer. So what we should be seeing in courts and in what we should be bringing as advocates for better streets are really lawsuits that try to reverse that finding of immunity and saying, actually, you're not
This
immune.
is my dream.
If you haven't, yeah, I mean, I think this is, and that's what I'll be talking about a little bit in this paper. But the theory is that, actually it's a whole separate paper, so this is a small part, but the theory should be that that you're not immune if you follow the conventions and design roads that we all know kill people.
Great. Deb Niemeyer?
Yeah, thank you. This was a great talk. I'm on non-visible because I realize like lawyers dress better than engineers do for conferences by video.
No shame.
So I'll change before my talk. The reason I'm patching in is that I think there's a deeper tension here. I'm a civil engineer by training and all kinds of things, but there's a deeper tension here that we've explored, which is that a lot of the updates to these standards are actually funded by public funds. So in other words, in the 1984 Green Book, the updates that have been done since 1984 have been funded through NCHRP processes, National Cooperative Highway, whatever processes. So not only are you paying for the update, you're then paying to read the updated material. And I think AASHTO essentially lives off this federal subscription model these days. And so you might be able to dig out a little bit about how this privatization has actually created an even deeper tension of doing something with public funds that is not then publicly available.
And let me just point out too that there's a major equity concern here, because if you look at the AASHTO board and if you look at the leadership, it's predominantly white and it's mostly male, and the various factors and corresponding income brackets and whatever that go along with being engineers. There are not citizens who understand can at least have some say over this in their daily lives. I mean, that's why I think this UpCodes case that I mentioned is so interesting, because if the courts say that UpCodes can't privatize and sell a law sorry, not UpCodes, but that the International Code Council can't do that, then I think it has really important implications here. At a bare minimum, we'll be able to see the standards that are being enforced across cities, states, and countries, and national. All right.
We have time for one more question quickly. Are there good examples of jurisdictions adopting the NACTO standards, that's the National Association of City Transportation Officials, and lessons that can be learned about the process and politics that got them there? This is obviously a big question, but we have time for just a small answer.
Yes, and I was just looking in my paper, if I put the number of cities, I think only 80-something cities have actually become members of NACTO, and in that case been eligible or able to work with them to adopt and integrate standards. So not to say other cities haven't. 1,600 cities have adopted complete streets policies. There are almost 40,000 general purpose local governments across the country. So you see that that's a very small number. Even within that, there's not so many cities that are supporting NACTO. So I do think that that's hopefully an area where we'll see a lot more activity, and that kind of framework and mentality will be supported, because it's really an important thing that we need to do to change, at the very least, the local roads that we all use every day. So with that, I'll just say thank you so much. Thanks again, Greg, for having me. Thanks, Haley, for organizing an excellent conference. And I look forward to connecting with folks afterward.